So it's an unusual discussion, but we're going to discuss today because at first glance it sounds strange that a legal system would discuss this, but every legal system has to deal with it. And in short, the topic is going to be, is it ever okay to take the law into your own hands? Now, I'm not talking about self-defense, right? To save your life, you certainly could use force, but you'll see the scenarios that the Talmud would bring. Somebody takes my computer. So what do? Do I have to call 911 or could I grab it back? And what happens if the person doesn't want to give me back my computer? Can I punch him in the face and take my computer back, or do I have to go to court? If I go to court, well, it's wonderful. I can go to court. I have to hire a lawyer. I have to wait a year. Then I have to go through the appeals process. It's not always the best solution to go to court. So that's going to be the discussion. We're going to discuss it from the perspective of the Talmud, and then we'll look at it from a little bit what the post-Talmudic sages explain, and maybe a little bit of how it's applied to in the modern law, at least in Israel and other countries. So we'll see. We'll try to give not a comprehensive discussion, but at least a taste of the parameters of the discussion. So we'll jump right in. We'll read some of the Talmud, and then we'll see what the broader issues are. So we start with a story. Can't go wrong with a story. So this piece of Talmud, oh, it's freezing up again. Give me just a moment. Oh, here we go. Okay. So this piece of Talmud happens to be in Tractate Baba Kama, which is the first tractate of the three that discuss monetary law. Baba Kama, firstly, will be on page 770. And the subject of the first, the subject of the tractate, generally speaking, is about damages and torts. If somebody damages his friend, do you have to pay? And here we have a story between two Talmudic sages, Rav Chisda and Rav Nachman. Now, as we will see later, Rav Nachman is the more prominent of the two. Rav Nachman, as we will see, is also considered an expert judge, to the extent that elsewhere the Talmud says that whenever there's a disagreement between Rav Nachman and anybody else, the law follows Rav Nachman, provided it's referring to a case of monetary law. In other words, in the Torah, there's all sorts of law. There's monetary law, and then there's religious law. Like, is this animal kosher or is it not kosher? Is this you have to fill in kosher or not kosher? So that's called isurim. In general, it's called prohibitions. But it doesn't just mean prohibitions. It means in laws of sort of more religious nature. And then the reading does not have to follow Rav Nachman, but in dinim, in legal matters of monetary law, the general rule is the ruling follows Rav Nachman, and that's why Rav Chisda asks a question, sends a question to Rav Nachman. He says, I have a question. What is the question? So it happens to be that okay, I'll stop sharing for a minute. Okay, I don't want to stop. It happens to be that in the tractate Baba Kama, it describes that if somebody damages somebody else, they have to pay. How much do you have to pay? Well, you have to go through a process of evaluating how much the damage is. So at some point, they simplify it. And the sages instituted that for certain types of damage or certain types of humiliation, which is one form of damage, there's a set fee. A set fee, so you don't have to go through the process of evaluating how much it's going to cost, how much it's going to be. So there's a set fee. That is what the Talmud is going to say, and we're going to read it inside. Now, it's almost funny because, as we will see, to hit somebody costs a certain amount of money. So it sounds almost funny. It's like, okay, can I pay in advance and take two? And is there? Oh, it's freezing.
Is it a kind of a form of acknowledgement that you?
Let me just see what's going on here. Are we freezing up? Oh, I'm sorry. This seems to be freezing. Go ahead, Vicky. Go ahead.
Rabbi Feldman, I was trying to ask you, that set fee, is it a kind of form of acknowledgement or like admission that you hurt or you damaged somebody?
It's paying damage, but instead of the court having to evaluate how much each damage is worth, it takes too much time. It's going to slow down the court. So as you'll see, we said if I hit somebody, there's a set amount, and that includes the damage, but also one form of damage. And there's 5 forms of damage. If a person damages somebody else, there are 5 forms of damage, and one of them is humiliation. If I humiliate somebody, I have to pay damages. So again, how much is humiliation worth? So there's a whole system in the Talmud. There's a whole system of evaluating, but we do that for the cases that are not set. But to make the process of justice quicker, they say that we have a set amount. We have a set amount for certain types of harm. So that's what we're just going to read a little bit, and we'll see what happens. That's not the main point here. It's not the main point. Okay, let's see what's happening. Again, it seems like my video is not working. I don't know why, but okay, that's just the way it is. Avchizda sent the following question to Rav Nachman. The sages said that when one strikes another, humiliating him, the judges determine liability according to the following formula. So we have a set formula. For kneeing, in Hebrew it's rechuva, kneeing him, he must pay 3 sela. For kicking, 5. For punching him, 13. So we have a set amount. So Rav Chisda asks Rav Nachman, I have a question. What happens, the Gemara asks, I wouldn't say the Gemara, but okay. In other words, this is Rav Chisda's question. Rav Chisda's question to Rav Nachman was, if so, for hitting him with the handle of a hoe, demara, and for hitting him with the top of a hoe, which is like a form of a axe that you use to plow, what amount is one liable to pay? So that's the question that Rav Chisda asks Rav Nachman. So the first thing what Rav Nachman does is responds, I'm sorry, this is very surprising, because the court has no power to enforce this ruling. And we'll discuss that in a minute. So we discussed in general, the law is as follows. And the law is that to be considered a rabbi, to have the force of the court, you need what they call smicha. Smicha means, in English, it means rabbinic ordination. But literally what smicha means to put the hands, that one rabbi puts the hands on the new rabbi and says, you now have permission to rule, you have permission to judge. The problem is that for smicha to be effective, it has to be an unbroken chain all the way back to Moshe. And when that unbroken chain, when that chain was broken, today we don't have a proper smicha. So the rabbis do not have the power to rule on all matters of the Torah. There's only certain matters we can rule. In addition, the law is that the court in Israel has more authority, in the land of Israel, has more authority than the court outside of Israel, the court of Babylonia. So the rabbis sitting in Babylonia judging have a very limited mandate of what types of law they could enforce. And what they cannot enforce is what they call a knas. And a knas means a penalty. What do I mean by a penalty? And this ties into Vicky's question. According to the law, if I damage you and I hurt you, I have to pay the damage. And that damage is what is rightfully yours because that's equivalent to what I harmed you. The issue here is what happens if the payment that I have to pay is more or less than the actual damage. It's not exactly what I harmed you. That tells us that the payment is not what they would call paying for the damage, but it's a penalty. It's almost like the Torah says, for public policy, we want to enforce this law. For example, let me give you an example. If I steal something that cost $5, or if I steal $5 from you, so the Torah says I have to repay double. So I stole 5, I pay 10. Now it so happens to be that there's a difference between the 5 that I stole and the 5 that's double. The first 5 that I stole is considered paying back money. So that I have to pay back on all circumstances. However, the second 5, the double, that's considered a knas, that's considered a penalty. And because it's considered a knas, a penalty, I don't always have to pay it. There are circumstances when I don't have to pay it. One circumstance would be if I confess by myself before anyone caught me. So if I steal $5 and I wasn't caught by the police or by the court or by the prosecution, instead I just come and I confess, I say I stole $5, then I just have to pay back the $5. I don't have to pay back the extra 5, the double. But more interesting to our discussion, the knas, the penalty, the extra 5, although it's a biblical law, the rabbis outside of Israel do not have the mandate to force me to pay the knas, the extra penalty. All they could do is make me pay what I owe, which would be 5. So the general rule is, if I damage, if the bill is exactly what I owe, that's considered money that I owe. If the bill is more or less, there are other cases less. For example, when you want a case for less, for example, let's say there's a case, the law says that, the Torah says, it's going to be later in this discussion, I don't think we're going to get to it, but later in the discussion, there's a case, we mentioned the case, but it's a well-known case, it's in the Torah, is the case of my cow, or my ox that gored another animal. So if you remember the law is that the first 2 times that the ox gores, the owner is only liable to pay half the damage because it's not really my fault. I didn't really know that my ox is going to gore. After the 3rd time, now the owner has to pay the full damage. Why? Because he should have known that he has a goring ox, and therefore I should have known that I have a goring ox, and therefore it's my liability and responsibility to guard the ox. If I didn't, I have to pay the entire amount. What am I trying to say? I'm trying to say when I have to pay half the damage, that's considered a knas, that's considered a penalty. Why? Because again, it's not the amount that I damaged. So I have to pay it, but it's a knas, it's a penalty. If it's a penalty, outside of Israel, the sages do not have the authority and they do not have the mandate to make me pay. That's the general rule. I just want to make sure you can hear me and I'm not frozen because I can't see myself. My camera's not working.
I can hear you.
Oh, beautiful. Okay. I don't know what's going on with this camera. Lately I'm having some trouble here. I'll try once more. Strange. Okay, what can we do? So what's the issue here? So now, once there's a set amount that if I knee somebody, or if I punch somebody, I have to pay a set amount, 3 selah, or 5 selah, or 13 selah, what do we know? We know that is not considered, it's not classified as paying money that I owe. Why not? Because it's not the damage, it's not the amount of damage. It's just an estimate, so to speak. It's just a set amount. If it's a set amount, then it's considered considered a knas, it's considered a penalty. So this explains what Rav Nachman responds to Chista. He says Rav Nachman sent him the following response: Chista. He was a little younger than him, so he was more referred to him like sort of like a student. He didn't call him Rav Chisda. He called him Chisda. Chisda says his name twice, sort of in shock and surprise. Chisda. Are you collecting a fine for humiliation in Babylonia, where judges are not authorized to collect fines? So he says, what's going on over here? But again, like a good rabbi, he knows he may not have all the facts. So he says, tell me how the incident itself transpired. Remember, there's no text messages, there's no emails. He's sending a messenger or a letter. So Rav Nachman, Rav Chisda sends a question to Rav Nachman. He says, what happens if somebody hits somebody with the top of the axe? How much does he owe? Because remember, we know there's a set amount for kicking, for kneeing. We know there's a set amount for punching. Is there a set amount for someone who hits somebody with the top of the axe? So the first response of Rav Nachman is, he says, look, Chisda, what's going on? You cannot collect, don't you know? You obviously know that you can't collect a penalty in Babylonia. And this is a penalty. Why is it a penalty? He translates penalty, I would translate fine. The point is, it's not the amount, it's not money you owe, because it's not the exact amount of the damage. Anytime there's a set amount, obviously it's not pegged to the amount of damage. It's considered a knas. And he says, you can't collect this knas. You can't collect this in Babylonia. So what are you doing? But he says, tell me what exactly happened. So Chisda sends him a fascinating story. Rav Chisda sent him in response. There is a certain cistern. Whoops. Close this. We have more space. Okay. There is a certain cistern. Cistern is like a form of a well of water belonging to two people, whose arrangement was to alternate its use, so that every day one of them would draw from it in turn. In other words, we have a cistern, the 6 days of the work week. We each take turns. One day I get it, the other day, every Sunday is me, every Monday is you, etc. It happened that one of them came and was drawing water on a day that was not his turn. His co-owner said to him, this is my day to draw, not yours. His colleague did not pay attention to him. In other words, it's me and my buddy Yankel, and I come and I see Yankel taking water on my day. So I say, Yankel, it's not your day. Yankel is ignoring me. What am I supposed to do? Go to court? Go into court. It will take a month. By then, he has all the water. So what did this guy do? The person whose turn it was, therefore, took the handle of a hoe and struck the person who was stealing his water, and then sued for who then sued for damages. Right? So somebody else, my partner was taking water in a day that did not belong to him. He comes to me. I'm sorry. So I stop him and I say, I approach him. I confront him and I say, don't take the water today. It's not yours. He ignores me. So I took my axe and I hit him over the head. Now that guy wants to charge me a penalty for hitting him, for humiliation. So Chisda sends to Rav Nachman and he says, how much do I make the guy pay? So it's funny. Before Rav Nachman said, you have a bigger problem. You can't collect that money in Babylonia. But here the response of Rav Nachman is absolutely fascinating. Rav Nachman says, really? The guy hit the person taking water that it wasn't his day? He only hit him once? He should have hit him 10 times, or actually 100 times. Rav Nachman said to him, in that case, he was right to do so. And he should have hit him even 100 times with the hoe. How could you do that? How can you take the law into your own hands? And we know that we're going to get to it later. There's a long-standing argument whether or not you're allowed to take the law into your own hands. Says Rav Nachman, even according to the one, which I'm going to put in parentheses, who disagrees with Rav Nachman, but even according to the one who says that a person may not take justice into his own hands, but should go to court, in a case where there would be a loss involved if no immediate action is taken, a person may take justice into his own hands. Okay, what's happening here? What's happening here is, in this case, if I file, someone's taking my water, if I file in court for damages, what's going to happen is I, at that point, will not be able to water my field. And if I can't water my field, there's going to be a damage. If there's going to be a damage, I'm allowed to take the law into my own hands according to everybody, says Rav Nachman. So let's just take this apart. If I walk up to you on the street and I take away your book and I take it to my house, so now there's going to be a debate whether or not you can grab it away from me or hit me over the head and take the law into your own hands. But the book, if you don't have a book, there's not going to be any monetary damage. Worst comes to worst, you won't read a book for a few days. But if I take away your water, and then you're not going to be able to plant your field, now your fruit are going to become damaged, or your vegetables are going to become damaged. And that is a loss. And you're allowed to intervene to stop the loss. So says Rav Nachman, but Rav Nachman says, everybody agrees with me. Now, I just want to make a little point here. Okay, so far so good? Is this clear?
Yeah.
Okay. I just want to make a small point here, and that is that in other systems of law, the distinction really falls out, because what happens if you steal my water and that causes a damage to my field? So in most cases, most systems of law, I could sue you for taking my water and for causing damage to my field. The problem is that under Jewish law, it's much, much more complicated to make somebody pay for what they call grama. Grama is an indirect damage. Some cases of indirect damage, you could make the person pay, but in general, if you want to make it, as a general rule, in the Torah law, it's very complicated, it's very difficult to make somebody pay for indirect damage. So it's not like if you take the water and my potatoes go bad, I could sue you in court, make you pay for the water, and make you pay for my ruined crop. It's much, much more complicated. In many cases, you can't make the person pay for their ruined crop because it's considered indirect damage. And like I said, that's a sugya, that's a subject for itself, which we're not going to get into right now. I just wanted to point out, to clarify, that there's a big distinction between a case where I take something that's not going to cause you other indirect damage to taking your water, which will cause you immediate indirect damage, which will cause indirect damage, which you will then lose. Going to court will not help you, right? Because you will not be able to get a remedy, get your money back in court because it's indirect damage. And you'll see later, if we get to it, there's other cases where we'll see the difference between a case where there is damage or there isn't damage. So this is the case, and this is the story, and this is what Rav Nachman said about the disagreement. We want to first, we'll take a question, then we're going to read the disagreement, and then we're going to try to get a little bit of bird's eye view and figure out what's happening here, and is this a good policy, a bad policy, and why the disagreement plays out, and what could the possible ramifications be. But in the meantime, go ahead. Go ahead, Vicky.
Yeah, I had a small question to clarify. Do we need witnesses in this case if somebody takes water or somebody takes something, or what do we do about law of witnesses? What somebody did something and nobody else knows?
So that's a very good question. Do we need witnesses? There's two ways I can answer that question. There's two ways I can answer that question, and it depends. So there's two ways. One answer would be that if the facts are in dispute, that's a separate problem. But let's assume everybody agrees with the facts. Let's say they would go to court and the parties would say, everybody would agree to the facts, right? Let's say my friend Yankel, who came and took water the day that did not belong to him. He would show up to court and the judge say, did you take water in a day that doesn't belong to you? Yankel would say, yes, I did. So the judge would say, what's your claim? So Yankel would say, okay, take your water back, but you have no right to hit me. I want to sue you for hitting me. And then the case would play out. In other words, that's one discussion. One discussion is, let's assume everybody agrees. Okay. But there's a deeper answer. The deeper answer here is that this is part of the deal. This is part of the question. We are talking about, I know, forget about witnesses. I see Yankel coming to my field taking my water. The point that Rav Nachman is trying to say, I don't have to worry about the court. If I know that this is mine, and if I know that somebody is intruding and taking my object, I have the right to defend myself, to defend my property. And I don't have to worry about the court, and I don't have to worry about the reaching the legal bar of proof that would be required in court. Now, we'll see later that everything here is debated and all the details, everything I said is up for debate. But from the simple level, that's Rav Nachman's point. Rav Nachman's point is, what do you mean go to court? You can't always go to court. Part of Rav Nachman's argument is, not always can I prove what happened, but I know this is my water. I know that my friend is coming in taking water on a day that does not belong to him. I have the right to hit him over the head to stop taking the water. That's Rav Nachman's argument. Now, we understand that's what we have to deal with over here. We understand, and that's the elephant in the room. The elephant in the room is that if you have a system where everybody can take the law into their own hands, there's going to be no law and order, right? A civilized society is a society where there's a court of justice. In fact, it's one of the 7 Noahide laws, one of the 7 basic laws of morality that are universal, not just for the Jewish people, but the Jewish people have to influence everybody to do, is to set up a court of justice. Because we understand that if everybody takes the law into their own hands, there's going to be absolute chaos and there's going to be the jungle. So
can I ask a
please go ahead.
Okay, hi. So it seems to me in all of these cases, there's 2 issues. The first issue being the damage of taking somebody's water.
Right.
And then and the associative losses of crops and human life, etc. And the other, it always seems to be this way. And the other concern has to do with the actual hitting or the violence.
Right.
So they're 2 separate issues.
Correct.
And I think if I think about those and so it depends on how a person wants to remedy the person coming in to take their water. Let's say you don't hit him over the head, but you push him away, which is less serious than hitting him over the head with an axe, right? That's a different
Correct.
kind of...
You're bringing up an excellent point. You're bringing up an excellent point, but you bring up an excellent point of how much, even according to Rav Nachman, how much violence is justified, right? Somebody's coming to somebody walks into this room and wants to take my computer. So I say, hey, it's mine. What happens if he doesn't listen? So then I can escalate, according to Rav Nachman. I could say, get off this computer before I hit you. If he doesn't, I could hit him. If that doesn't help, I could pick up the chair and hit him with a chair. So the question is, how much violence could be used? That's a valid question.
But the suit is that if I were suing somebody, I would sue them separately for taking my water, and I would sue them separately for hurting me.
Correct. Correct. But if I'm the defendant, I would want those 2 cases tied in. I would say,
Why?
I'll tell you why. Because I would say that, of course, I'm not allowed to hit, but I'm allowed to hit to protect my property. In other words, the justification to hit in this case would be, I'm allowed to hit to protect my property. But that's the big question. The question is, are you allowed, and you articulated it very well, are you allowed to use violence to protect your property and protect yourself against loss? Or do I say, I cannot use violence to protect myself. If somebody takes my item, someone takes my object, someone wants to cause damage to my property, okay, call the police, go to court.
You see, but when that's happening, a person doesn't think like that always, like a lawyer or a judge. They think, I got to just do this.
Okay.
So if I were...
Should society say that everybody could defend themselves, taking the law into their own hands? Or should society say, look, we understand that sometimes it's a pain to go to court, but we have no choice. We cannot allow people hitting other people, claiming I'm just defending my property. You can't do that, because then there'll be violence in the streets. So that's the 2 sides of the discussion, and that's really the idea here. That's the dilemma. A dilemma is that both sides have some validity. On one hand, if I'm going to go to court, it's going to cost me time and money. On the other hand, if I say I could just hit the guy trying to take my water, then what kind of society would that lead to?
Suppose you warn the guy before you say, listen, I've warned you twice. Next time I'm gonna hit you.
If he doesn't listen, no, not next time. Someone's coming to take your water or your computer. I say, look, step back before I hit you. He continues coming. I say, I'm gonna hit you. That's really what the guy's in this case. The point is that the guy's ignoring. Am I allowed to use violence to protect against a loss? Or do we say, I'm sorry, if you get, we set up a court of justice for that, and it's not up to you to take to use violence.
I just have one quick question, and then I back up. So I think if you're protecting your child or your spouse or your mother or your father or anybody, then that's a different circumstance than if you're protecting your water.
Correct.
It's on the person who does, before they do the act, to decide for themselves what's the right way to handle it. It's a different situation. I don't know. I think if somebody were hurting my child, I would hurt them if I had to, and I would be absolutely right in doing it.
Correct. You are correct that when it comes to protecting yourself or your life or your limb, you are allowed to use violence in defense, in self-defense. That's not a question. That's clear.
Especially if they're using violence, they've set the ground rule.
Correct. The question is, am I allowed to use violence to protect my property? That's the
Are you?
That's the question. Well, we're going to see here that Rav Nachman says that in some cases it's universally accepted. But let's I want to read at least one more passage, and then we can discuss it further. Says Rav Nachman. So here's the essential disagreement. This is as it was stated that Rav Yehuda said a person may not take justice into his own hands, whereas Rav Nachman says a person may take justice into his own hands. That is the essential disagreement between Rav Yehuda and Rav Nachman. And again, Rav Nachman was the guy of our story, and he said, what? You only hit the neighbor once? You could have hit him 100 times if that was necessary to stop him from taking your water. So basically, when Rav Chizda asked Rav Nachman, could we make the guy, how much do we make the guy pay for hitting his neighbor with the tip of the axe? Now, it doesn't mean you hit him and you split his head and he ends up in the hospital. It means you hit him in that way, and he got the message, but it's humiliating because a punch, if someone hits you, it's humiliating to you. So he says, I want to bill them for, how much do you pay for humiliating somebody with the top of the axe? Rav Yehuda, Rav Nachman said, I'm sorry, you don't have to pay anything because the guy was defending his water. And again, because we have this long-standing debate between Rav Yehuda, who says you should not use violence, you should not take the law into your own hands. And Rav Nachman says you may take the law into your own hands. However, the Talmud clarifies that the disagreement is only in certain cases. But in this case, a case such as the water, the Talmud says, everybody would say that a person could take the law into their own hands. Where there is an imminent loss that will be suffered if the injured party does not take action, everyone agrees that a person may take justice into his own hands. They disagree only when there is no imminent loss that will be suffered. Rav Yehuda says that a person may not take justice into his own hands because since there is no loss, he should go before the judge to have him enforce the law. Rav Nachman says that a person may take justice into his own hands since he is acting lawfully, as he is clearly in the right. He need not trouble himself to go before the judge to have him enforce the law. And that's a disagreement between Rav Yehuda and Rav Nachman. And from here to the end of the page, we're not going to have time to read it, but from here to the end, the next couple of lines, is back and forth. We're trying to prove which opinion is right, and we leave off with we don't know. The Talmud does not clarify who is right, and that leaves us to the discussion of what the post-Talmudic sages rule, and that is a fascinating discussion in itself. So that is the big picture. That's the section from Rav Nachman, about the question of could you take the law into your own hands? But now I want to analyze a little bit and bring up a few points. And again, nothing I'm going to say is all inclusive and all comprehensive, but at least some thoughts to help us think about this question. The first thing I want to talk about is a fascinating idea that between the two rabbis, Rav Yehuda and Rav Nachman, Rav Yehuda's occupation was that he made a big yeshiva in a Babylonian city called Pumbedita. One of the what became a famous yeshiva after it was established. It's not clear if he established it himself, but he took it over. He was in charge of a school. He was in charge of a yeshiva. It's more like not really a school, but it's a yeshiva for adults. But that's where it's a place where they study Torah. That was Rav Yehuda. Now, Rav Nachman was also a great sage, but his job he wasn't really a teacher. He was a judge. He actually ruled in practical cases. And he was a prominent judge, as we mentioned before. It's not clear in the Babylonia, the Jewish people had some sort of self-rule. They were ruled by a Jewish leader called the Reish Galuta, who literally was Aramaic for the head of the diaspora. And the king and the government gave that person certain political powers, sort of that the Jews can have their own autonomy, so they don't have to get involved with how the Jews live their life. That's the way it was in Babylonia. So there was an institution called the institution of the Reish Galuta, the head of the exile. And Rav Nachman was very close to the head of the exile of his days. He was either ruled in the court under the head of the exile of the diaspora, or he actually was close to him. That's the details are not so important. What's important is that Rav Nachman is an expert judge. Now, if I ask you before you study the piece of Talmud, let's say there's two rabbis. One is in yeshiva where they're studying the Torah, and one is actually a judge. Which one would you think would be the advocate for the position that a person may take the law into their own hands? The judge or the non-judge? So this is an interesting question. What do you think? Would the judge want you to come before the judge, or would the judge say, yeah, take the law into your own hands? So I'll speak for myself. Personally, I would think that the judge is supposed to support the justice system, and the judge is supposed to be an advocate for the justice system, and the judge should say, look, this is why I get paid. This is why the government pays me. So if there's a problem, you go to court. You can't solve your problems with punching a guy in the street with an axe. That's going to create a jungle, no law and order. So it's fascinating that Rav Nachman, who's the judge, says, sure, take the law into your own hands. Rav Yehuda, who's the scholar, who's not necessarily part of the justice system, says, oh, no, unless there's immediate loss. But in general, yeah, you can't take the law into your own hands. If somebody wants to come and take your book, right? You want to go to the beach and read a book. Problem is that the library only has one copy. So somebody comes and grabs your book. So Rav Yehuda says, too bad. Don't grab it back. You have a problem, go to court. It will take you 2 months to get it back. It doesn't matter. So, but who's the advocate for the court? The non-judge. The judge is the one who says, oh, you have a problem, solve it yourself. Oh, you want to come to court, but you don't have to. So that's one just surprising, not surprising. That's one very interesting angle to think about it from the perspective of who are the rabbis who put forth these what is their personal biography, and how does that inform the ruling they say? So there's 2 points you can make, and then you pick the one you like. I'm just going to make 2 points here, and there may be other ways to look at it. I'm going to give 2 possibilities why the judge would say, take the law into your own hands. First possibility would be that the judge really knows the limitations of the legal system. And I think Vicky pointed out, you come to the judge is going to say, were there witnesses? Can you prove? Was there a contract? Right? So the justice system is very good to solve disputes in a peaceful way. They're very good at that. But is the justice system good at arriving at a just conclusion? This argument would be Rav Nachman, who knows the justice system from close up because he's the chief judge, says, I'm sorry, you people, you think the justice system could do much more than it could do. You're giving it a mandate that's too great. It can't always solve problems. It can't in a just way. So therefore, if you know that you're in the right and you're enforcing a right that belongs to you, you have the full right to act. And you don't have to go to court because maybe the court can't always give you the right solution. Rabbi Yehuda, on the other hand, who's in charge of a yeshiva, he's a rabbi. He understands that he's trying to build a community in a new city in Babylonia. He understands you cannot build a society if everyone's going to take the law into their own hands. So he's inclined to say, go to court. His job is to build community. So therefore he says, I support the court. The judge on the court says, well, I know the limitations of court. So actually, ironically, maybe don't come to me. So that's one way to look at it. Another way to look at it is looking from the historical perspective. Now, we would expect that a court system that says that in some cases you could take the law into your own hands is going to be a very weak court system. In other words, the court system can't always solve the problem, so they say, take the law into your own hands. But a legal system that has a strong and robust legal system would say, come to court and we will solve your problem. But historically, not surprisingly, it's counterintuitive, but once you think about it, it makes a lot of sense. The opposite is true. When the legal system is weak, the legal system usually does not allow you to take the law into your own hands. Because the legal system is so fragile that if everyone takes the law into their own hands, people will do so in scenarios when they're not allowed to, and the legal system won't be able to step in. But historically, when a legal system becomes entrenched and becomes more powerful and more robust, then the legal system is willing to say, in some cases, you could take the law into your own hands. And if you overstep, don't worry, the court will be here to protect, right? So ironically, where there's a weaker legal system, they don't allow any taking the law into their own hands. For example, in Britain, I'm told, I'm not a legal scholar, but I'm told in Britain, what I'm reading is that initially, in the beginning of the legal system, you were not allowed to take the law into your own hands ever, even to protect your life. If someone comes to you and wants to harm you, the law says you can't defend yourself. Why? You're using violence. So there's no killing in self-defense because they were afraid if they're going to say people could take the law into their own hands, chaos will break out. In those days, what would happen would be that we say, you defended yourself, you're guilty. Oh, we're not going to kill you, because what would happen is the king, usually in most cases, the king would pardon the person acting in self-defense. But the law cannot say, we would not say you could take the law into your own hands, even for self-defense, when the law is weak, when the court system is weak. However, when the court system is strong, we're less afraid historically, we're less afraid than the court system would allow, than the legal system would allow for people to have more right to take the law into their own hands, because we're not afraid. What are we going to afraid? We're afraid that someone's going to punch you in the face with an unjustified way. So you'll take them to court and the court will defend. So in other words, the strong court actually, ironically, allows for the people to have more autonomy in enforcing their rights. If you look at it this way, then perhaps this is the answer. Rav Nachman, who had a strong court, so in that city, I believe he lived in Naharda. In Naharda, there's a strong legal system. So Rav Nachman is more open to say, look, you could take the law into your own hands. If you step out of line, the court will step in and create the balance. Rav Yehuda, who comes to a new city and they're trying to build a community, there's no strong court system. If there's no strong court system, he's a little bit afraid to say, take the law into your own hands. Because then what happens if someone goes too far? That was Seth's concern. Someone goes too far. If someone goes too far, there's no court system to prosecute. So in this case, this would be the other reason to explain why is it that Rav Nachman, who's the judge, says, oh, you don't always have to come to the court. Take the law into your own hands. Why? Because he knows that there's a strong court system to create that balance. So this is just two ways of understanding. Then we could take this thing further, but I don't know if we have time because we'll see so far. Let's see if there's any questions. Go ahead, Vicky.
Well, I just want to ask if there's if there's a third dimension to that, and it's a fear of the heavenly court. So the stronger morality of the society, the more we can be lenient as far as allowing to take the matter into your hands, because you're afraid of the heavenly court. You're not going to do something that's illegal in the.
Correct. That's the scholars are saying that. People are saying that, and that's why Like I said, if there's a loss, everybody agrees. Both Rabbi Yehuda and Rav Nachman says you could take the law into your own hands, right? So there's something unique about the Jewish system that would allow that. What is that? So you're absolutely on target. That assuming most people have a sense of morality, so it's not going to create chaos in the streets because people are less likely to overstep that boundary in a society where people believe that justice is not just what the court it's not just the court can catch you. You're not just afraid of the policeman, but you're afraid of divine justice as well. So that's an excellent point. Now I just want to take this one more step. Take us one more step, and again, we have to stop in 5 minutes, so we can't go as far as I would like to go. But here we go. What is the law? What becomes the law? So most of the codifiers of the Talmud, in other words, most of the post-Talmudic sages who codify and rule according to the Talmud, they say Rav Nachman is right. You are allowed to take the law into your own hands. Why do they say it, even though the Talmud does not explicitly say the law follows Rav Nachman in this case? It's because I mentioned this earlier, that there's a general rule that because Rav Nachman was an expert judge, therefore, when it comes to monetary law, the law follows Rav Nachman. So there's a general rule. Halacha ka Rav Nachman bedini. The law follows Rav Nachman about monetary law. So this is a case of monetary law. Am I allowed to hit somebody to defend my water? And therefore, the law follows Rav Nachman. So most people, Maimonides and the Rif and the Code of Law, the Shulchan Aruch, they all rule according to Maimonides, that according to Rav Nachman, that you are allowed to take the law into your own hands. Now, throughout the years, in different societies, in different countries, this thing was limited. They limit the scope of this law. And we don't have time to get into that discussion of all the limitations that were placed. And different places, there was fear that it's going to get out of hand. So there were different limitations placed on the law. But in principle, Maimonides, Code of Law, everybody says the law follows Rav Nachman and you're allowed to take the law into your own hands, at least in certain circumstances. That's beautiful. That's consistent with the general rule. The law follows Rav Nachman in monetary law. The problem is that there's one sage, his name was Rabbi Ephraim, is the son-in-law of the Rif, who was the teacher of Maimonides. And Rabbi Ephraim says, no, sorry, the law is like Rav Yehuda. You may not take the law into your own hands. And all the sages wonder, how did Rabbi Ephraim get this conclusion? How does he rule that the law follows Rav Yehuda if there's a general rule that the law follows Rav Nachman in monetary law? So how could he go against the general rule in the Talmud? And this is a brilliant response that when I heard it for the first time, it was actually surprising. It was enjoyable to see how unexpected that was, but it's just fascinating. Rabbi Ephraim says, sorry, this is not a case of monetary law. The law doesn't follow Rav Nachman. It's a case of religious law. Are you allowed to hit the guy over the head? So it's not really a case about the water. It's a case about hitting somebody. And because it's a case about hitting someone, it's a case of religious law. If it's a case of religious law, we don't have to follow Rav Nachman. So Rabbi Ephraim says, sorry, I'm not following Rav Nachman. So to me, that was just fascinating how we have a case and everybody says, yeah, religious law, a monetary law, we follow Rav Nachman. One guy comes and doesn't want to follow Rav Nachman. So he says, sorry, it's not religious law. It's not monetary law, it's religious law. So I thought that was very clever. So I figured I would share it. So that's the story in short for today. Again, the big picture is, are you allowed to take the law in your own hands? Does the legal system have benefits? Yes. The benefits are that it creates a peaceful way to solve problems. The problem is that the legal system also has a cost. The cost is that sometimes it will take time to enforce. It's a pain to enforce, and it's not always the best way to get justice. So the question is, does the individual person still maintain the right to defend his own interests or does he have to always go to court? The answer is he does. And according to most opinions, at least in some cases, you could enforce your own law. Now, there's so many restrictions, but the main restriction is it has to be an item that is tangible. If I say you owe me money because I did a job for you, or you loaned me money last year and you didn't repay me, so I'm going to go into your house and take something. No, that's not tangible money. It's a tangible object that's here. tangible damage that's here. But again, we don't have time to go into the scope of the limitations on this law. But the principal question is, do we outsource the enforcement of law to the court exclusively, or does every individual member of society still maintain the obligation, the right, and therefore maybe does he maintain the right to enforce the law and protect his own assets? And the Jewish law says in many cases you can. There are exceptions, but in many cases you can, because again, part of this is that we don't really fear that it's going to get out of hand, either because there's a strong system of justice or because there's a strong feeling of moral maturity. And we understand that for most people will follow the moral code and do what is right. And if they don't, hopefully there'll be a strong court. And my guess is that in areas where there were not a strong court, there were more restrictions on the law. So if you want to it's an interesting topic would be to follow and read about all the restrictions placed on this law in post-Talmudic times and think about where were the restrictions placed and what the society looked like. That will keep us busy for a while. Okay, ladies and gentlemen, thank you for joining. This has been enjoyable for me. I really appreciate it. And thank you. Toda rabba. Have a wonderful afternoon.
Thank you, Rabbi.
Thank you.
Thank you.